This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why it's always appropriate to give yourself the same limits you give to third parties, and why an underinsured motorist statute limited coverage to the same amount as the coverage. In Majdoleen A, Khattab, the Administratrix of the estate of Affan Mohamad Khattab, a suit was filed against Berkley Regional Insurance Company, and that company suit resulted in a summary judgment in favor of the insurer. In the decision of the Court of Appeals for the Fourth Circuit on October 19, 2023, who interpreted the clear language of the statute and the insured's UIM coverages. At issue was an insurance policy issued by Berkley Regional Insurance Company. The policy has a general liability limit of $1 million and an uninsured motorist coverage limit of $70,000. The case turned solely on the legal question of what the relevant coverage limit under the insurance policy was for an accident caused by a motorist whose insurance coverage is less than the amount of the claim damages and less than the amount of the general liability limit, but greater than the amount of the uninsured motorist coverage limit. Virginia mandates that an insurance policy's uninsured motorist coverage limits must match the policy's liability limits unless anyone named insured rejects the additional uninsured motorist coverage by notifying the insurers provided in the statute. There was no dispute that Berkley complied with the notice requirement for the uninsured underinsured coverage limits pursuant to the statute, and there was no dispute that the insured properly limited the uninsured coverage to $70,000. With respect to underinsured coverage, the statute provides that the policy shall provide underinsured motorist coverage with limits that shall be equal to the uninsured motorist insurance coverage limits and shall obligate the insurer to make payment for bodily injury or property damage caused by the operation or use of an underinsured motor vehicle to the extent the vehicle is underinsured. The appellant argued that the underinsured coverage limit remained at $1 million, equal to the policy's general liability limit. However, the appellant did not pay for UIM coverage of $1 million. Appellant overlooks that the statutory default sets underinsured motorist coverage equal to uninsured motorist coverage, not the policy's general liability limit. Because the uninsured motorist coverage was properly limited to $70,000 and the policy does not provide for underinsured motorist coverage different from the statutory default, the district court correctly concluded that the applicable coverage limit was $70,000 and affirmed the Court of Appeals affirmed the district court's decision. In my opinion, it appears to me to be ridiculous to buy liability insurance limits with $1 million to protect third parties that might be hurt by the insured, but refuse to buy the same limit or more if the insured is injured by an uninsured or underinsured motorist. The insured sought the coverage that was needed, not the coverage the insured acquired. This video was adapted from my blog Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And you can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,600 blog postings. If you found this blog to be useful to you, please tell your friends and colleagues about the blog and the videos and let them subscribe. And you can also subscribe to my locals community and to my Substack publications if for a very small fee if you're interested in getting further detail about insurance, insurance law, insurance claims, and insurance fraud. Thank you for your attention.